Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. So today we're going to talk about a subject that is pretty much every lawyer's favorite subject, legal fees. I'll have more in just a moment. Well, just like everything else in the law, there are rules and regulations with regard to the setting of fees. But it's very interesting if you look at the subject of legal fees around the country, because what may be a reasonable fee, for example, in Kansas City, Missouri, is not a reasonable fee in the District of Columbia. And I'll show you that here in a little bit. I'm going to use Rule 1.5 of the Missouri Rules for Professional Conduct. And that rule I have sort of edited a little bit to take out the parts that don't apply directly to our discussion here. But here is what that rule says. A lawyer shall not make an agreement for, charge, or collect an unreasonable fee or an unreasonable amount for expenses. The factors to be considered in determining the reasonableness of a fee include the following. And then the rule lists a number of factors. And those factors are the time and labor required, the novelty and difficulty of the questions involved, and the skill requisite to perform the legal service properly. So there's three factors inside of one factor. Lawyers sometimes have difficulty with math, but we can do 40% of any number. The likelihood, if apparent to the client, that the acceptance of a particular employment will preclude other employment by the lawyer. That's a situation, for example, where you're going to take on a major corporation. There's going to be a huge amount of discovery, and it's going to eat up 30 or 40% of your time for the next 2 to 3 to 4 years. Well, obviously that means you're not going to be able to take other clients during that time. That increases the risk to the lawyer, and that can be a problem. The fee customarily charged in the locality for similar legal services. Now, this is one of those that is, I think, probably the predominant method by which courts award fees. They will look at what other lawyers in the area charge for a given service and determine based on that whether or not the fee is reasonable. And sometimes it is and sometimes it isn't. The amount involved and the results obtained. That's especially important when you're dealing with contingent fee cases. The time limitations imposed by the client or by the circumstances. Sometimes you have to get a case on file within a matter of hours, for example, to get a preliminary injunction or something like that. Quick legal work still needs to be good legal work, and you need to pay for that if you're a client. The nature and length of the professional relationship with the client. In other words, if the client has a long-standing history with that particular law firm, they may wind up paying a little more or sometimes a little less for services. The experience, reputation, and ability of the lawyer or lawyers performing the services. You see this a lot in class action cases. You want to have somebody who's handled a lot of class actions, who understands the risks, who understands all the various rules and what you need to have a class action case. And in those situations where you have somebody who's really an ace, sometimes the fee is a little bit higher. And then finally, whether the fee is fixed or contingent. Now, those are the factors that courts will use in determining whether or not a fee is reasonable. But the first person who gets to determine whether or not a fee is reasonable is the client. And that should be done at the outset of the case and not at the end of the case. And unfortunately, a lot of lawyers wait till the end of the case to start talking about fees. If you go in and you hire a lawyer and he doesn't tell you exactly what he's going to charge and for what, then that's a problem. So you need to get a fee agreement in writing every time you hire a lawyer. In fact, here's what Rule 1.5 says about that in Missouri. The scope of the representation and the basis of the fee rate or the fee and the expenses for which the client will be responsible shall be communicated to the client, preferably in writing, before or within a reasonable time after commencing the representation, except when a lawyer will charge a regularly represented client on the same basis or rate. Any changes in the basis or rate of the fee or expenses shall also be communicated to the client. So, for example, if your lawyer says, okay, I'm gonna charge $250 an hour, but every year my rate will go up by 10%. So next year it's going to be $275 and so on. So it's important to get that down in writing so that you know exactly what the fee is and what you're going to have to pay. The rule recognizes that some lawyers charge by the hour and some lawyers charge a contingent fee. Now, when somebody is working a 9-to-5 job and they get badly injured through somebody else's negligence, they likely don't have $20,000 sitting around in the bank to hire an hourly lawyer. So that's why there are contingent fees. It's designed to make the law accessible to people who could not otherwise afford it. And a contingent fee is just what it says. A contingent fee means that you do not have to pay the lawyer a legal fee unless and until the lawyer collects money on your behalf. Now, the key word there is collects money. So it would be perfectly possible for me to go out and get a judgment against somebody who had absolutely no money to pay that judgment, and then turn around and say, hey, I got a $10,000 judgment. You're never going to get paid by the guy, but I got you the judgment, so here, I want my 30% or my 40% or whatever it is. Well, a lawyer can't do that. He takes his fee out of what is paid, not out of what necessarily is awarded by the court. Here's what the rule says about contingent fees. A fee may be contingent on the outcome of the matter for which the service is rendered, except in a matter in which a contingent fee is prohibited by Rule 4-1.5d, and I'll talk about that in a moment. A contingent fee agreement shall be in writing, signed by the client, and shall state the method by which the fee is to be determined, including the percentage or percentages that shall accrue to the lawyer in the event of settlement, trial, or appeal, litigation, and other expenses to be deducted from the recovery, and whether such expenses are to be deducted before or after the contingent fee is calculated. So, why does that matter? Let's suppose you have a $10,000 check from the insurance company for an automobile accident, and the lawyer had to go out and hire an expert witness. And between the expert witness and all of the costs paid into the court to file the lawsuit, you have a total number of expenses of $1,000. Well, if the fee basis is off the top, meaning the lawyer's 40% or 30% or whatever percent is calculated off the total recovery, then he gets 40% of $10,000. And if the fee is calculated after expenses are taken out, then he gets 40% of $9,000. So he gets somewhere between $4,000 and $3,600 in fees. You can see why when the fee is calculated and how the fee is calculated would be very important to a contingent fee client. The rule then goes on to talk about expenses. The agreement must clearly notify the client of any expenses for which the client will be liable, whether or not the client is the prevailing party. Upon conclusion of a contingent fee matter, the lawyer shall provide the client with a written statement stating the outcome of the matter and, if there is a recovery, showing the remittance to the client and the method of its determination. So, If we have made copies of documents, for example, medical records, if we have paid the medical records provider to, $400 to get a copy of the medical records, we have to provide copies of the invoice and an itemized statement to the client if the client requests it. And we have to itemize all of those things in a fee statement, which we hand to the client and which they sign in order to get the payout from the law firm. That's very important because if there is a fee dispute, if somebody thinks something is being charged that is unreasonable, then it needs to be addressed at that time, not after the checks are already cashed. Now, there are a few types of cases where a contingency fee is not allowed, and here's what the rule says about that. A lawyer shall not enter into an agreement for, charge, or collect any fee in a domestic relations matter, the payment or amount of which is contingent upon securing of a divorce or dissolution of marriage, or upon the amount of maintenance, alimony, or support, or property settlement in lieu thereof, or a contingent fee for representing a defendant in a criminal case. Now, the rationale for these rules are different. In the first case, you don't want to see, this was written when women were much less empowered, but you don't want to see a stay-at-home mom who doesn't have any income of her own have to give up part of her maintenance, what would often be called alimony, or her child support in order to pay off her lawyer. You want the fee to be based on an hourly rate, or one or the other of the spouses will often be responsible for paying both sets of lawyers. Now, that seems unfair in a lot of instances, but that is indeed what happens in many of these cases. The basis for not allowing a contingent fee in a criminal case is pretty significant too. You don't want to encourage a lawyer to cheat in any way. You don't want them to hide evidence or do other things that would impair the way the justice system is supposed to work. So if a lawyer has a financial interest in getting his client acquitted, if that's what his payment is derived from, he's going to do things that he might not do otherwise. So that's the basis for that rule. The rule goes on to talk about fee disputes, and here's what it says about fee disputes. When a fee dispute arises between a lawyer and the client, the lawyer shall conscientiously consider participating in the appropriate fee dispute resolution program. This does not apply if a fee is set by statute or by a court or administrative agency with authority to determine the fee. So, for example, in a case involving the Veterans Administration, the Veterans Administration sets the fee. I believe it's 10% in the VA, which makes it difficult sometimes to find a lawyer in VA cases. One type of case where fees are provided for, at least in Missouri, is under the Little FTC Act, called the Missouri Merchandising Practices Act. And if a fee is awarded by the court determines that fee. What is a fee dispute resolution program? It is a program administered by the state bar where a mediator will sit down and talk with both parties to see if they can come to some resolution of the fee dispute. Usually it means both sides give a little. Nobody walks away with everything, but everybody gets something. So those are the important parts of that rule. But as with many things, sometimes you have to tattoo information on the forehead of people in order to get the message across. And all of these rules have comments to the rule. So I want to read you the comment about the reasonableness of the fee. And here's what it says. Rule 4-1.5a requires that lawyers charge fees that are reasonable under the circumstances. The factors specified in 1 to 8 are not exclusive, nor will each factor be relevant in each instance. The rule also requires that expenses for which the client will be charged must be reasonable. A lawyer may seek reimbursement for the cost of services performed in-house, such as copying, or for other expenses incurred in-house, such as telephone charges, either by charging a reasonable amount to which the client has agreed in advance, or by charging an amount that reasonably reflects the cost incurred by the lawyer. So, For example, you might have an agreement with a client. A client might agree to pay 10% above what the phone company charges for long distance. And in that situation, the firm would mark up its long distance bills that were incurred in that case. For the most part, most law firms do charge for copying. They charge for the fees that are provided. And some law firms will also charge for what's called a line of credit. Now, the lawyer will advance the fees and will often pay the expenses of experts and that sort of thing, and they will do that with borrowed money. And because they have to pay the bank back on that line of credit, whatever amount is apportioned to that file for the amount of interest becomes an interest expense that is then collected at the end of the case. And that is done, oddly enough, to protect the client, because otherwise, if you don't collect that fee, you've just given the client an interest-free loan for sometimes as long as 3 years. And the IRS can, and sometimes does, come back and try to collect taxes on that as income. So, now that we understand how, at least in Missouri, legal fees are calculated, how does that translate in the context of other places around the country and other types of law? Well, this is something called the Laffey Matrix. The Laffey Matrix, which I've always found funny because when I think about Laffey, I think about funny. Anyway, the Laffey Matrix is named for a guy named Laffey who came up with it. It is the matrix that the district court in the District of Columbia uses to determine the reasonableness of attorney's fees in cases where the government or someone else is responsible to pay the legal fees. If you look at this, a lawyer who is 20 years out of law school can charge $997 an hour. Now that probably sounds expensive, and in fact, I think it's pretty expensive. Would I pay a lawyer $997 in Kansas City, Missouri to represent me? Probably not. And the reason is because I would probably insist on a contingency fee or a blended fee rate, which is a mixture of contingency and other factors. So I wouldn't necessarily be, because I am a sort of a savvy consumer, I would not wind up paying a fee like that. But many businesses do, many insurance companies do. But the place where legal fees really go off the rails, in my humble opinion, which is neither really that humble nor particularly well informed sometimes, but in my opinion, the place it really goes off the rails is in bankruptcy. Now, when a company enters into bankruptcy, particularly Chapter 11 bankruptcy, what they tell the court is, I've got bills I can't pay. And in order to stay in business, you've got to make some of these bills go away. So one of the first things that happens is the law firm that represents the debtor comes in and says, we've been retained, here are our disclosures, and we very much want to represent this person, and the client has agreed to pay our reasonable fees. And then every 3 months or so, they submit a fee statement for the fees that were earned. This is a fee statement from Latham and Watkins, and in order to avoid the stigma associated with these, which I believe are outrageous fees, I have blacked out the names of the lawyers in this case. This was downloaded from a bankruptcy case that is on file in Delaware. And if you look, you have lawyers here charging almost $2,000 an hour as legal fees that in a bankruptcy case where the bankrupt obviously can't pay its other bills. So why would it be appropriate for the bankruptcy lawyer to get such a huge amount of fees when it it's like a vulture on a dead animal, picking the bones clean and not really leaving much for anything else. All right. This is my personal opinion, right? It's not the law. It's just my personal opinion. And yes, bankruptcy courts approve these kinds of fees every day in Delaware. And the only solution to that is to write to your congressmen and senators and say, the system's broken, you need to fix it. Because honest to goodness, the system is broken and it does need to be fixed in bankruptcy. At any rate, that's what I have for you today on legal fees. Hopefully it's been educational and interesting. If you have any questions, drop them in the comments down below. With respect to the comments, I would be very interested in what you think a reasonable fee is for a lawyer in your area. Pick a type of case, divorce, a car accident, that sort of thing, and tell me what you think a reasonable fee would be to pay your lawyer in that situation. And maybe we can get some good comments that would be useful and helpful to not only to me, but maybe to other lawyers. This is one of those areas where I am seriously thinking of doing a law review article to sort of make this issue, make people aware of this particular issue. So again, if you haven't already, please like, share, subscribe, let people know about this. And as always, thank you for watching. I hope you have a marvelous day. I will catch you on here next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.